Hello, this is Matt on the Moon Lambo channel. Brad Garlinghouse and Chris Larson's legal team has absolutely ripped to shreds the SEC's most recent argument that there was sufficient legal clarity and really has been for the entirety of the time that Ripple has been conducting business surrounding the blockchain and crypto asset class as a whole. It's a completely bogus argument. And so this all stems back to the article that's on your screen right now, which is from July 14th, 2021. I covered this in great detail on that day that it was released. And this piece written by Commissioner Hester Peirce and Commissioner Elad Roisman, who are, by the way, 2 of 5 commissioners tasked with deciding whether or not to bring legal complaints against individuals and businesses. These 2 of 5 state that there currently is not sufficient regulatory clarity in the blockchain and crypto space, something that everybody listening to this will understand. And I think the SEC, if they were being unbiased, and maybe they'll say it internally to themselves but not out loud, of course this is true, because a person with half a brain would know that this is the case. There clearly is not sufficient regulatory clarity. Hester Peirce cites in this piece how she's constantly just bombarded by individuals seeking clarity on specific matters, but you don't get that in other asset classes. And so Ripple, along with Brad Garlinghouse and Chris Larson, because they're also defendants individually, they all filed documents to the court making their case, submitting this as evidence. Look, see, even the SEC is saying that there's not sufficient regulatory clarity. And then the SEC lawyers came back and said, no, this is just the personal opinion of Hester and Elad trying to diminish the weight that they carry, even though they're 2 of the highest ranking individuals that work at the SEC. And now today, we have Ripple's response to that. So there's been a lot going on. And I'm going to cover this in great detail, but I do want to be clear at the outset. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything I say or write. All right, and so here's a tweet from James K. Filan. He is an attorney within the XRP community, but he's not part of Ripple's legal team, and he's not part of the SEC. And so he wrote the following. Individual defendants respond to SEC's letter regarding public statement by Commissioners Peirce and Roisman describing SEC response as going, quote, on to publicly rebuke these 2 commissioners' considered views, end quote, that there is no clarity. And by the way, I'm also going to share with you opinions from Jeremy Hogan, another attorney who's within the XRP community, as well as Arturo Portilla, who's as well an attorney within the XRP community. And so let's go ahead and dig in and get this little party started, right? It's always a good time here. And so this was written to Judge Annalise Torres, and this is from Ripple's legal team, of course. We have Matthew Solomon. You've probably heard that name a bit if you've been following my videos, or really any XRP YouTubers' videos, frankly, as well as Martin Flumenbaum. So they respectfully submitted this document together. And here's what they wrote. This just came out today. We write on behalf of defendants Christian A. Larson and Bradley Garlinghouse, together the individual defendants, to briefly respond to the SEC's letter filed on July 21st, 2021. The SEC concedes that this court may take judicial notice of a recent statement by 2 of its own commissioners acknowledging the uncertainty concerning the application of the securities laws to digital assets. But it goes on to publicly rebuke these 2 commissioners' considered views that merely acknowledge what is plain and obvious to all, that even today, quote, this is from the SEC commissioners, quote, there is a decided lack of clarity for market participants around the application of the securities laws to digital assets and their trading, end quote. Truer words have never been spoken. I know, it's all obvious to us. But that's why I keep saying with the SEC, what can we do but speculate? It's got to be a power and or money grab. Why the hell else are they doing this? Because it's just not logical. Like, they've got to be gaining personally somehow. Anyway, the SEC then asserts that the commissioner's statements are legally irrelevant to their claims of aiding and abetting against Mr. Larson and Mr. Garlinghouse. This gratuitous attempt to re-argue its flawed position by way of an unauthorized surreply is meritless. It is plain, as the individual defendants point out in their motions, that there was at the relevant time, and remains today, a, quote, decided lack of clarity, end quote, regarding whether digital assets generally, and XRP in particular, are securities. The SEC's aiding and abetting claim requires the SEC to prove that Mr. Larson and Mr. Garlinghouse knew or were reckless in not concluding that XRP was a security as long as 8 years ago. Yet even today, 2 of the 5 commissioners of the agency acknowledge that, quote, questions and confusion persist in the marketplace, end quote, thus negating any claim of historical recklessness against Mr. Larson and Mr. Garlinghouse. That's why, look, I got to tell you before you go any further, I am hoping that the cases specifically against Garlinghouse and Larson, I hope that they get dropped. That would be powerful. And indeed, even when this happened, I remember all sorts of attorneys stating at the time, this is unprecedented. Like, this just doesn't happen in a non-fraud case, because there's no alleged fraud here. In a non-fraud case, to go after the executives doesn't freaking happen. So right there, it already started to feel like a witch hunt. And I'm like, okay, what's the reasons for this? Because on the surface, with me not having a legal background, I didn't realize until I was told by multiple lawyers, no, this is not normal. And so you got to think, okay, what are they doing? Is it just a strong arm tactic? And I think yes, although the good news is, as I've been reporting on this channel, it's been backfiring for a number of reasons. But yes, that's why I keep saying, like, these are not good people. These are not ethical people. Anyway, the document continues. The SEC's extraordinary public airing of its internal debate only highlights why the court must dismiss the SEC's claim against the individual defendants for aiding and abetting Ripple's alleged violation of Section 5 of the Securities Act. The SEC's letter does serve to focus the inquiry before the court. There can be no debate about whether the regulatory status of digital assets in general, and XRP in particular, was so clear that the individual defendants can remain accused of being reckless in not recognizing it as such. That issue was not, and is not, anything close to clear. The SEC does not contest this point. Instead, it responds that it, quote, is not required to prove that the individual defendants knew or recklessly disregarded the legal consequences of their actions, end quote. That would allow the SEC to rest an aiding and abetting claim solely on the knowledge of the circumstances that constitute the primary violation, i.e., the individual defendant's knowledge that Ripple sold a digital asset that had not been registered as a security without plausibly alleging the necessary element that the individual defendants knew or recklessly disregarded that these sales were improper. But, as the individual defendant's motions make clear, under the correct legal standard, which the SEC itself has advocated for in court and applied in administrative proceedings, the SEC must demonstrate that the individual defendants knew or recklessly disregarded that Ripple's offerings and sales of XRP required registration and securities, and not that those transactions were improper. And so if you were listening to my video the other day where I was talking about, I said, look, I haven't seen, maybe I missed it, I said, look, I hadn't seen that the SEC make this claim. Not that I know every single aspect of this case. I mean, I get it. Like, I follow this regularly, but no matter who you are, you're not going to retain every single tiny detail of this thing. And I just didn't recall that the SEC had made the case that they don't need to prove that Garlinghouse and Larson were reckless. And so in the last video where I was talking about this, I said I've been made clear by all sorts of attorneys, including those in the XRP community, like Jeremy Hogan on his channel Legal Briefs, that there's this concept of scienter where you have to prove that there was an understanding that what they were doing was wrong, or that they were completely reckless. And so here you see Ripple responding to that. This is the first response that I had seen to that. Not surprisingly, it's the next response. And they're saying, no, SEC, that is the incorrect legal standard. And I'm going to assume that Ripple's legal team is correct and not the SEC, because the SEC, I can't trust them further than I can spit. And frankly, they don't deserve anyone's trust. Look at what they have done. If you've been following this case, you know that they will make any argument they can, even if they don't believe it, even if it's disingenuous, and they'll just see what sticks, which is why I've said many times also, if I'm the judge in this case, I'm offended at some point that they're testing my intelligence to this level. Because you don't need to be a super genius. Even if you're just reasonably logical, a typical person, you can see the arguments that they're making are highly flawed. It's very clear to see. And so anyway, this court document continues. The SEC has alleged nothing improper about selling XRP other than its claim that those sales required registration with the SEC as a security. But that, in turn, requires the SEC to show that the individual defendants knew or were reckless as to XRP's alleged classification as a security. Given the regulatory uncertainty that commissioners of the SEC now publicly acknowledge persists even today, the SEC's aiding and abetting claim must fail. That's my golf clap. That's my golf clap. You're killing it, lawyers. The SEC also draws false analogies to prior decisions that offer no support for its aiding and abetting claims. And then they cite cases like Kick and Telegram, which I covered in my previous video because the SEC brought it up. And then the SEC argues that the claims against Mr. Larson and Garlinghouse should be decided on the basis of Howey and the cases applying it, just like every other case in the digital asset space has been decided. But the Kick and Telegram cases did not involve any claims against individual defendants. Well, how about that? This is not apples to apples. Indeed, with the Kick and Telegram cases, as I stated, remember I stated just a few minutes ago, it's not normal to bring executives up against, charges up against the executives in a non-fraud case. Here they did it. This is not apples to apples like the SEC is pretending that it is. There are different standards for conviction here. The SEC is pretending that's not the case, but they know better and they don't care. And then this continues. And the NAC Foundation case did not involve claims of aiding and abetting under Section 15 of the Securities Act. Instead, the individual defendant in that case, unlike Mr. Larson and Mr. Garlinghouse, stood accused of perpetrating fraud. Well, how about that, like I've been saying? These decisions in no way support the SEC's aiding and abetting claim against Mr. Larson and Garlinghouse, and there are, of course, numerous other distinctions between those cases and this one. The SEC's arguments concerning Commissioners Roisman and Peirce's statement only highlight that the SEC's position is legally untenable. As a matter of law, Mr. Larson and Mr. Garlinghouse cannot have been reckless in connection with the disputed issue of whether XRP is and was a currency or a security. Thus, the aiding and abetting claims against Mr. Larson and Mr. Garlinghouse should be dismissed. More golf clap. More golf. You get 2 rounds of golf clap in one Moon Lambo video. That makes you special. See, and so this is completely absurd. This is why I keep saying, like, it really does. It's infuriating because it's like they're trying to trick you. They think you're stupid enough you can be tricked by this stuff. That is what they must think, or else why are they doing it? It's complete garbage. And so here's what Attorney Jeremy Hogan had to say on this. Although the statement by Commissioners Peirce and Roisman was a blessing for Ripple, it is even doubly so for the individual defendants for which the SEC has to prove that they knew or recklessly disregarded securities laws. Expect to see the Ripple reply shortly. And then somebody asked Jeremy, has this changed your view for when you expect a resolution to this farce? And clarity is given. Jeremy wrote, the statement from the commissioners doesn't change my estimate for timeframes, except I think it makes it more likely that the individual defendants might win their motions to dismiss. And obviously, I think it puts Ripple in a better position as far as settlement negotiations. Wouldn't mind that one bit. Here's what Arturo Portilla said, another attorney within the XRP community. Now that 2 SEC commissioners have publicly said that, quote, there is a decided lack of clarity around the application of securities laws to digital assets, end quote, where are the crypto lawyers who argued Ripple had enough clarity because it received advice from its legal counsel? So-called crypto lawyers, right? Exactly. You gotta love that. That was such a bogus argument. The idea that they said that there might be a claim, which would have been a bogus claim, by the way. They're just highlighting a risk, not that it would have been a valid risk or a valid claim, but the risk was real that the SEC could bring a bogus claim. Sure. And so where are those attorneys now that Hester and Elad are saying this? You gotta love this stuff. It's ridiculous. And so there you go. There's your latest update and the nonsense going on in the SEC versus Ripple case. I'll wrap it up there. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.